SJC-12601, Commonwealth v. Christian Germain.
Levin, good morning.
Good morning. May it please the court, Patrick Levin on behalf of Christian Germain. At the heart of this court's jurisprudence regarding the admissibility of show-up identifications is a common sense assumption that, at least to some extent, the inherent suggestiveness of that procedure will be counterbalanced by the freshness of the victim's memory of the crime. We now know that that's not really right. That even when they're conducted very soon after a crime, witnesses perform very poorly in show-up identifications, often in the studies that we have, no better than chance.
Now, when you say we now know, is that science changed since Silva Santiago, or is there additional research?
There's some additional research since Silva Santiago. I'm mostly speaking of, in terms of we now know since the test requiring good reason was established, which is quite a bit further back.
Yeah.
But I'm not here this morning asking the court to tear down that whole edifice of case law. I'm just asking the court to take seriously the dangers that are posed by the show-up identification procedure.
Can I ask you something, Mr. Levin? Just if we follow through with this and using this case, obviously for an example, were they to arrest your client and then wait a day and do a proper array sequentially or whatever? Is that what you want us to hold?
In terms of the confidence that we could have in the accuracy of the identification, I think that certainly would have been the best practice.
I'm trying to tease out, say we say you're absolutely right when we look at the social research. I'm saying you may have caught him, so to speak, as the Commonwealth would argue, red-handed, meets a general description, hustled back to the scene. Whether or not there should be instructions is a good point, and whether or not people should be together is another great point. But I just think the practical reality is, they have two options if we say don't do this anymore. One is to let them go, and that ain't going to happen.
No, you're right about that.
And the other option, which is going to happen, is an arrest, and then later on down the road, some type of show-up ID with all the inherent issues of memory loss.
Yes, an arrest to be followed at the soonest practicable time by a lineup.
Yeah, is that what you really want?
I mean, ideally, I think if there is probable cause to arrest someone, then that would be the best practice. But that's not really the relief that I've asked for in this case. Wasn't argued.
But we got to think about the rule, though, right?
Yes.
The rule that this would compel, if we follow your logic, it's going to lead to more arrests.
Well, I'm not sure how many more arrests we're talking about.
Do you doubt that this clears people sometimes?
I know it does sometimes, but all the best research we have shows that when a witness is confronted with a single person who they're aware the police have in custody and think is the perpetrator, they're very likely to confirm that police suspicion.
What exactly did the police say before the witnesses made the identification?
So in this case, what Officer Guthrie said, I believe, was, we have someone, we're not sure if it's the right person, we want you to come and identify him.
So how was that providing the witness with any indication they ought to confirm it for the police?
Okay, so first, it was good of him not to say, we caught the guy, let me come show you to him.
Which used to happen.
Which that is essentially what used to happen, and we've come some way since then.
We got someone.
Yeah.
Basically.
In terms of the warnings, the recommendation of the study group, and certainly the best practice would be a warning more along the lines of, You're going to be shown some people. The person that you saw may or may not be among the people that you're shown. It's just as important to clear an innocent person from suspicion as it is to identify a guilty person, and that regardless of whether you identify anyone right now, we're going to continue to investigate this. Now, those last two warnings really are important because even when you're given the warning, the may or may not warning, as it's called in the literature, that doesn't actually seem to relieve the psychological pressure that a witness feels to confirm the police's suspicion. That even when it's an unconscious pressure, we have research showing that witnesses feel compelled to identify the person that's presented to them, and often they think that this is their only chance.
Are these, is this research based on college students doing practice eyewitness identification for a study, or are they actual crime victims and real show-ups?
So there's a wide range, and so some of the research is lab studies of college students or other participants who you can find at a university. There is some survey research about how often people get identified at show-ups in real-world crime scenes. And then there actually is a really excellent study that came out fairly recently. It's cited in my brief. It's the Eisen study.
Was that brought before the motion judge?
No, that postdates the motion. But I really do commend it to the court's attention. What happened in the Eisen study is that they told the subjects that they were testing something else, and then during that experiment, they staged a crime. One of the people who the participants in the study thought was another participant in the study stole one of the laptops that they were using and ran away. And so then half of the administrations, they told the people that was staged for research purposes. Now we'd like you to come and see if you can identify the person. And the other half, an actual police officer who helped the scientists design the study came and spoke with the participants and brought them to what appeared to be an actual police show-up. And the findings in the study are really quite striking. In the field condition...
I mean, but again, this is extra record evidence that hasn't been tested down below. And we also have a public safety component here. A person's firing away at a crowd, right? He's firing into the air. Don't we want to try to catch that person?
Yes, absolutely, Justice Kafker. We
and-
absolutely do.
But
But
but I don't, if we don't have some kind of show up, I mean, back to Justice Gaziano's point. I mean, I understand how you do the show up is critical.
Yes.
That's a separate question. But to not have a show up in these circumstances seems crazy.
And didn't the defendant concede below? Didn't he concede below that there was good cause?
yes, we have conceded both below and on appeal that under this court's prior case law, this is a good cause for a show-up situation.
Does that take care of the public safety concern that Justice Kafker was talking about?
Well, to a certain extent, it does in this case. I do want to address it briefly, though, if I may,
Go ahead.
because the idea that conducting the show-up is good for public safety relies on the idea that the show-up is reliable in the first place.
Well, I'm not sure that's necessarily true. They're two separate questions. You know, what do we do when someone's on the street robbing people and then firing at witnesses? And then we understand that show-ups have memory issues, and we may have exaggerated how reliable they are. I get that completely, but I just don't see the way around Justice Gaziano's point is that we are conducting a show-up. The question is how we conduct it.
Yeah, I mean, I'm not really taking issue with that at this point, but I do want to push back a little bit because if you have there's basically two scenarios that can be presented on the street, right?
But I just want to clarify, and if you could finish, but you're asking us, I mean, as I see it, there are three different things going on. One is how we do it with the instructions, which is very well taken, how it's done with two people, which is another point very well taken, and then the larger one, get rid of show-ups.
Yeah, and
Okay,
to be
you're
clear,
asking us to get rid of show-ups.
to be clear, the amici are the only party in this case that has requested that remedy.
Okay.
So I wanna speak to the circumstances of the show up in this case. But I will just briefly say that basically, if you pick someone up on the street, either you have the right person or the wrong person. And if you have the right person and there's probable cause to arrest them, and you do, then your public safety concern is, you're good. If you have the wrong person, then you still have this public safety problem, because the right person is still out there somewhere.
Well, but
And if
that's
you
a-
bring the
that's-
witness to
but
look
that's
at the
a-
wrong person, what we see is that between 30 and 50% of the time, they will say, yeah, that's the right person, and the actual perpetrator stays at large.
Well, but that's a separate question, though, whether the police are, once they've had the show up, should they stop doing their investigation because they've got their guy or not? That's a whole that's a fourth issue in terms of Justice Gaziano's 4 issues that we should be dealing with, right?
That's true, but in practice, when they arrest someone and the victim identifies that person as the person, it's very unusual for the intensive search for that person to continue.
So what did the motion judge get wrong? The special elements of unfairness, Mr.
So
Levin?
the thing that the motion judge got the most wrong is the idea that that bringing both witnesses together to participate in the show up did not render that show up so unnecessarily suggestive as to be conducive to irreparable mistaken identification.
And that's our special element.
That's right.
What's the best practice in that situation? Obviously, we know it's not a good idea, that it's very dangerous to have 2 people, witnesses, alleged victims, view alleged perpetrator at the same time. And the case law is clear on that, and there's a lot to back that up. So what's the best practice for the police officer in a circumstance like this, where you've got the witnesses, alleged victims, really scared, concerned about whether or not they'd make an identification? Because we're obviously going to, it seems to me, reinforce that this shouldn't be done. So what's the best practice to come out of this case?
Just add one more fact, which is only one of the witnesses speaks English, the
Right.
other one doesn't.
So the best practice here, particularly in light of the language barrier, the best practice would be, you have a half dozen cruisers in this few block radius already. What you do is you bring the witness who can speak English alone to the show up in the back of one cruiser, and another cruiser takes the other victim home. There's no reason they both have to participate in the show up in the first place.
But, so you give up a possibility of a second, is that good for you? I mean, that a second possible witness, one may recognize it, the other one may not. You decide to send the second one home as opposed to delaying the second one?
Well, what you're asking me for is the best practice. The best practice is one victim should participate in the show up. If she identifies the suspect as the perpetrator, that person is arrested, and the next day, the other witness is brought to participate in a double-blind, non-suggestive lineup, and we see if they independently confirm that identification.
Now, if they happen to be husband and wife or roommates, are we going to send them to a separate hotel so that they don't communicate with each other, instruct them in advance? Doesn't this get to be awfully convoluted?
I mean, I don't know about that, Your Honor. All I can say is you should never bring 2 witnesses to participate in a show up together. You never should do it.
Now, is there any consequence to the fact that both at the same time, according to the evidence, both said that's the guy?
That certainly would be relevant under federal law in terms of the reliability of the identification. And I think it probably also is relevant under state law in terms of the admissibility of a subsequent non-suggestive identification under the independent source test. But under the Article 12 due process test, that is not relevant to the question whether the procedures that the police used in this case were so unnecessarily suggestive.
But aren't we concerned with whether that had an influence on the procedure, had an influence on the witnesses? And here, if they simultaneously at the same time spontaneously make the identification, where's the link?
Your Honor, this is the difference between state and federal law in this area. And this is Commonwealth versus Johnson, the 1995
You're
case.
just saying that Manson versus Braithwaite doesn't help because unnecessarily suggestive is step one.
Right.
If it's unnecessarily suggestive, go to the independent source. Don't stop on the way for the reliability.
And there's a concern expressed in Johnson about deterrence of unnecessarily suggestive procedures. And I know that's how we often think about these types of exclusionary rules, but I think in some ways it's more enlightening to think of it in terms of encouraging the police to be extremely careful with what essentially is trace evidence. This is a kind of evidence that if you don't handle it extremely carefully, you destroy its evidentiary value.
So what I think overall you're asking us to do is to tighten up the show-up procedures so that all the protections we have during photo arrays, separate witnesses, more robust instructions should be applied to out on the street.
Yes, and I mean, absolutely, all protections that apply to photo arrays apply a fortiori to show-ups because they're already inherently suggestive. Whereas with a lineup, if you double blind it, you can remove that suggestiveness from the equation almost entirely.
Why shouldn't the certainty question be within the judge's discretion, depending on the entire circumstances of the case?
Because a statement of certainty following a show-up identification is never going to be reliable. All the research shows that every show-up witness is overconfident in their identification. And regardless of whether they're making correct or incorrect identifications, witnesses express a high degree of confidence when they only view one person and they know that person is the police's suspect.
So what if they had said, I'm not really sure? I think it's him, but I can't be sure. Would that be admissible?
Well, that certainly is something that has important evidentiary value because what we know from the research is that show-up witnesses in particular are overconfident at almost all levels of confidence. And so if they do not appear to be confident in the identification, that is a serious red flag. I'm not sure if that's him. The science tells us almost always means either I didn't really get a look at the guy in the first place, or that doesn't look like the person I saw.
So how do we have a rule that it's not admissible if the person says he's certain, but it is admissible if the person says, I'm not sure if I'm certain?
Well, it's only one rule. It's a rule about the probative value of the statement. And a statement has probative value if it's a statement of uncertainty, because we know that witnesses who are not certain are extremely inaccurate. But if the statement is one of certainty, that lacks probative value because we know that show-up witnesses who express certainty may or may not be accurate. There's essentially no correlation at all.
Don't you have that ability to argue that balancing test now, if it lacks probative value, to exclude?
Yes, but in the area of eyewitness identification in particular, a lot of these principles are somewhat counterintuitive, and I think this
You can
court...
make that pitch to the judge, though, to the trial judge.
Well, that's sort of the problem, right, is that you make the pitch to the trial judge, and who knows what's going to happen in any individual case, but we know in every case that a statement that I'm really sure that the person who I was shown in a show-up was the same person is not a reliable form of evidence.
So what do we, Silver Santiago, which applies only to, right now, only to lineups, says you should ask the person how certain they are.
Yes,
And
that's absolutely best
believe
practice.
all of the police protocols ask that.
Yes.
So are they wrong to ask it?
No, they're absolutely right to ask it. It's vital to have a record of that information from before any feedback could occur, because we know that by the time trial comes, the witness is almost always completely certain that they picked out the right person because that person now has been prosecuted for the crime. But the fact that something is an important piece of evidence to gather in the course of an investigation doesn't ultimately mean that it should be admissible at trial.
But, I mean, there's a difference between asking somebody at trial whether they're certain. I get that. But one of the reasons you want to ask somebody at the time of the ID, the first ID, how certain they are, is precisely to get on the record their level of certainty for fear that it will grow by the time of trial.
Yes, yes. And so the statement of certainty, particularly if it's a statement of uncertainty, that's going to be extremely relevant to a judge's evaluation of the identification's admissibility in the first place. But that doesn't mean that the jury, who we know is not able to discount witness certainty, that the jury should hear that evidence that sort of swamps anything else that they might hear about the suggestiveness of a procedure or.
It's exculpatory.
Well, Your Honor, if it's exculpatory, it is legitimately probative.
But this is a heads I win, tails you lose rule.
No, it's a rule that only evidence that has probative value should be admitted before the jury.
But it has, even when you've got expert testimony that's going to allow the jury to put into context that just because you say you're certain, particularly you're going to have an expert coming in now, you're going to have Mr. Eisen come in now and say, you know, when you say you're certain at show-ups, you're almost always wrong. And then the jury can't hear all of that together?
Well, so two things to say about that, Your Honor. The first is that it shouldn't be a burden on the defendant to call an expert witness in every identification case, because if they don't, then evidence that will totally swamp everything else the jury has heard is going to be admitted. And the second is, it's hard for juries to sort this stuff out, and a lot of it is very counterintuitive.
Now, what do we do with the fact, or what consequence, if any, is the fact that our model jury instructions specifically address the issue and say, but you should also consider that a witness's expressed certainty in identification standing alone may not be a reliable indicator of the accuracy of the identification, especially where the witness did not describe that level of certainty when the witness first made the identification.
That's certainly an important instruction if evidence of this type is going to be admitted. But evidence of this type, with an exception, and I want to make this clear, that eyewitness certainty is highly correlated to accuracy if it's elicited immediately after a non-suggestive double-blind lineup. That if the police have done everything right and there's no suggestiveness to the identification procedure, then in fact what the science shows is people are pretty good at knowing whether the person that they see in front of them is the same person that they saw before, or at least in evaluating their own certainty about that. But any form of suggestiveness totally destroys that ability. And so
That's just for lineups, though, you say, right?
yeah, only where there's no suggestiveness in the ID procedure at all. So a show-up is inherently
So
suggestive.
if you have a show up and the witness says, I think that's the person, I'm not quite sure, that comes in.
Potentially. Although I think more likely, I mean, depending on,
Your position is that never happens, but.
well, depending on a host of factors, I think often if a witness is shown someone in a show-up and says that they're not really sure that that's the person, that show-up probably.
Or I say, it's 100% him, and then the person sitting next to me goes, I don't know, it might be him. You want that evidence in, right?
Yes, that if the show-up is going to be admitted in the first place,
Right.
that a statement that casts doubt on it is probative.
Right.
Have you looked far enough down the road on this, as far as if you don't have a statement about certainty, about what that does to the in-court ID, because you don't have a statement about the out-of-court ID being equivocal? Have you thought that through down the road at all?
No, I'm not, so,
You-
I want to make sure I
understand my
understand.
question.
So your question posits that the police would stop asking witnesses if they're certain?
You're right. So your issue is more that it just not be admissible.
Yeah, Police should
but-
absolutely be asking immediately after every identification how certain that witness is. They need to ask that immediately in every case. And one of the problems in this case.
It won't change the unequivocal, doesn't,
No, it doesn't change any of that. It just changes what's admissible at trial.
All right, I understand.
And so one of the big problems in this case is that both witnesses receive explicit feedback from each other before they express their degree of certainty in their identifications. And so we know, I mean, it's hard to imagine a case where a witness's statement of certainty means less than this one, where they both are reinforced by each other's
but
identification.
isn't that a good point that goes to balancing probative value and undue prejudice in the judge's discretion with enough assistance in a decision that says, this is not whether you, Your Honor, believe in how strong a show-up is or not. You don't infuse your own view of it into it. But if you have a situation like you've just outlined, then the defense counsel should be able to articulate it's palpable, the concern there, and should be able to have it excluded as a matter of common law.
Yes, I agree. It should be excluded as a matter of common law. Any statement that I am sure this is the person.
No, I'm talking about the reinforcing afterwards.
Yeah, that any statement that I am sure this is the person that follows any form of feedback or suggestiveness should not be admitted at trial.
Okay, thank you.
Thank you very much.
Mr. O'Sullivan?
Good morning. May it please the court. David O'Sullivan for the Commonwealth. With the court's permission, I'll begin in the same order as my brother and first address the instructions that were given prior to the identification in this case, and then address the broader question of whether, to what extent, this court should require instructions precede all show-ups. In this particular case, I would make a slight correction, but I would say an important one to what my brother said. As the judge found, the instructions that preceded this identification were as follows. We have a man in custody. We do not know whether it is the robber. Not that we're not sure. We do not know. And third, we need you to tell us whether or not he is in fact the robber. I think that's a small difference, but one of significance, because a statement that we're not sure suggests a stronger belief that he is. It's just that we're not certain. Here, the police, I would say commendably, said, we don't know whether this person is in fact.
There's absolutely no harm in mandating the fullest Silva Santiago instructions, right?
Thank you. And I think this is important. And one principle that has emerged, certainly over the last 10 years in this court's eyewitness ID jurisprudence, is that we don't change police procedures on the ground that we think it won't hurt, or on the ground that we're pretty sure that the officer would have enough time to do this, which I concede, obviously, he would likely have enough time to give the two instructions that my brother complains of their omission. I'm sorry.
No, go on.
But what we do is we change police procedures only if, and to the extent that, there is a solid scientific basis for doing so. Now, what has not been cited here is any scientific basis for a belief that in the very different context of show-ups that we acknowledge are, generally speaking, more suggestive than your average, than a lineup or photo array, that these pre-identification instructions have any efficacy in reducing the chance of a mistaken identification.
Your assumption, I mean, we don't always rely on solid scientific basis. If we feel liberty needs to be protected, we don't necessarily require a scientific study. I mean, the Miranda warnings, I'm not sure they all came out of scientific studies, did they?
That's correct, but I would say our concern here is fundamentally different than in Miranda. There we're trying to secure a right that the defendant has and to advise him of it. Here, as my brother points out, our ultimate concern is with reliability. And it would be extraordinarily embarrassing if this court were to impose, as a matter of a judicial requirement, that certain procedures precede a show-up identification that were later found to have no effect on the ultimate reliability of the identification that ensued. Now, of course, in 2009, in Silva Santiago, this court had an absolutely solid basis based on specified studies to impose that requirement and require that it precede all photo arrays. What we don't have is a similar body of scientific knowledge here. So the study group does recommend that a battery of instructions precede show-ups. But I would urge the court to examine what the study group said and what they cited. It's at page 72 of the study group, and they don't cite any studies that have anything to do with this very different context. What they cite are studies that have to do with the context of lineups and photo arrays, which I would concede.
Maybe I'm missing this, but if we've mandated this in a lineup, in a double-blind lineup, with all its protections, and then you're saying we shouldn't import that to a show-up, which is by leaps and bounds much more suggestive
Right.
than a lineup.
Well-
So we shouldn't have more protection for something that's more suggestive? How does that make sense?
The question is whether it's protection. So what my brother has cited in his principal brief are two studies that I think actually illustrate this point in sharp relief. The New Schatz study, which purports to be a comprehensive evaluation of show-ups, notes that the use of unbiased instructions has never been examined in the context of show-ups. And in the Smith article, which is a 2018 article, there was a study of pre-show-up instructions, which the study authors acknowledged that particular instruction couldn't be used in the quote-unquote real world, and that the authors explicitly said contributes to a small body of scientific knowledge in this area. What the court doesn't do is impose procedures on police without a solid scientific basis for
Isn't
thinking
it
they
even
help.
more than that, though? Shouldn't there be a reticence, when you're dealing with a lineup, the overwhelming majority of the time, the crime scene has already been secured, you're off to a different place and a different time. Here, it's you're oftentimes in a crime scene situation or in the aftermath of a crime scene situation. And it seems to me that there should be some reticence that we impose what the police should do in that circumstance, as opposed to see what they do and deal with that by way of instruction and alerting the jury to the concerns that arise from the police conduct.
I would agree and have sort of two follow-ups to that, Your Honor. First being that the clock is ticking. Counsel and I would certainly disagree about the line of demarcation, the temporal line of demarcation, after which there's a drop in the reliability of show-up identifications. At some point down the line, this court has drawn the line typically at 2 hours, it's approved ones as long as 3 hours, and in fact, a few days, I believe, after the event. But at some point, the accuracy declines. Counsel, in his reply brief, has suggested that a study suggests 18 minutes is the line of demarcation. So added procedures begin to gain more significance in this context when we realize that the accuracy, the freshness of the memory that would support the reliability of the show-up identification
There's a problem
is
with your,
decreasing.
there's an inherent problem in your argument. You're arguing to us that it was really good that the police officer here gave the instruction that he did. So if you think it is really good, and if police protocols say it is a good thing to do, why would we not say that that is part of what it means to reasonably perform a show-up? I mean, we've said there are two things for a show-up. One, there must be good cause for it, and secondly, they must be conducted in a manner that's not needlessly more suggestive than they inherently are. Why is this not part of that second piece?
Well, the question here is, he was instructed that we do not know whether this is the person. What he wasn't instructed was those two additional.
I understand, and I know
Right,
that,
yeah, yeah.
and I know that Silva Santiago, I wrote it, was applied only to lineups, and I also know that it was not premised on any. It was that we noted the existence of studies, but we didn't declare that this will diminish the suggestiveness. We simply said that this is the better practice in Silva Santiago when we established that protocol. So why are you saying that we must have some firm empirical basis beyond what you've described before we can say it's a good idea for police to do it.
Because everyone's goal here, the Commonwealth and the defendant, is reliability. And if a particular procedure doesn't tend to support or to instruct the eyewitness in a way that makes more reliable what they say after the instruction in regard to the identification that they give or don't give, then the instructions become, or the procedures become pointless.
Did you argue that below in front of the motion judge? That we had this instruction, but it didn't matter. You're kind of biting the hand that feeds you, aren't you?
I'm not sure I
But
understand.
you have a motion here in front of a judge. You want this to come in. You say this, we know show-ups, you do the pat language, show-ups are inherently, it's an exception, blah, 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 but this one was okay. And one of the reasons it's okay is because we had this instruction. Now you're telling us instructions don't matter.
No, I'm saying.
Aren't you? And that's what the chief asked you. You're biting the hand that feeds you
No,
as
no.
far as the fairness of this show-up.
Well, this gets to my second point that I was going to address with Judge Lowy, precisely because we don't know. The answer to the big question that I would say this court has
That's
to.
what you said to Judge Lang? We don't know if this was any good, but here it is. Here's the evidence. Take it for whatever you're worth.
Well, the jury are the finders of fact. Now, what we don't know, the answer to the question that the court has to decide, which is, do these instructions matter in terms of improving the reliability of the identification? The resounding answer, I would say, maybe and maybe not. We don't know at this point. That's why it goes into the mix with everything else in the jury's evaluation of the weight of the evidence. And in that evaluation, they are assisted. They're assisted as they were in this case by counsel's cross-examination, counsel who were apprised and well-versed in the findings of the study group and in the recent science on this issue. They're assisted also by the judge's instructions.
You don't really want to go back to the old days where we got him, right? You know, I take it does matter even you'll agree that it matters what the police officers say. We don't want to say, hey, we caught the guy red-handed, we want you to identify him, right?
It would certainly go in, it would certainly be relevant. It would tend to
More than
establish.
relevant, right? You don't want us to condone that, do you?
To condone,
That we've got the guy, we caught him red-handed, come look at him and tell us we got the right guy.
of course not, of
Okay,
course
so
not.
we obviously are instructing on some way that helps take into mind what we've learned about eyewitness identification, right? And how to avoid bad identifications versus more reliable ones.
Correct. And
So I guess I'm confused why your officer gave one instruction we think is pretty good, right? And we haven't, and they're asking for a second one, which I'm not sure isn't implicit in the first one, but I mean, we do want to have these show-ups make for a more reliable identification, don't we?
of course, and
And we're not going to require scientific certainty here. But go ahead.
no,
sorry.
and scientific certainty wouldn't be the standard, of course, but, you know, if I could refer back to the Gomes decision, what the court said, obviously, there's conflicting studies on almost every point, but what,
That's not true.
sorry?
That's not true. And Gomes specifically says we've only done that which there is essentially scientific consensus.
This is my point. So what Gomes said was we are going to look at the generally accepted principles that have reached a level of scientific consensus and identified 5 or 6 of those principles that became part of the Gomes instruction, which became ultimately part of the instruction that is given in every case and was given in this case. I would submit that in order to change police procedures, we should have a similar level of certainty that it's necessarily going to help the outcome in terms of reliability. But if, to the extent that the court does impose a requirement
Okay,
akin to
Silva Santiago was not a requirement. Silva Santiago simply said that the failure to do so may renders it unnecessarily suggestive, and then you need to evaluate whether it's so unnecessarily suggestive that it violates due process. That was the Thomas decision.
right, and
The fact of the matter is, it took us, police forces have basically adopted it as their own. It took us about 7 years before we even had to consider the issue.
correct, yeah. You know, With respect to whether it's a requirement, it's certainly something that results in an instruction that is unfavorable to the Commonwealth if they fail to do it.
Isn't that warranted?
Absolutely, and it may lead to suppression of the evidence. So whether it's required or recommended, I think is a distinction without a difference. In effect, this court has required it, not on pain of necessarily suppressing the evidence, but on pain of receiving a very unfavorable jury instruction and maybe facing suppression.
De Giambattista type of
Yes,
instruction.
yes. Now, with respect to the extent any Silva Santiago protocol is imposed by this court, I would just submit that it be imposed flexibly in light of the very different context that police are facing in that circumstance. Now, if I could move to the second issue, which is the failure to separate the two. And I would start with the fact that the question before you is whether there was good reason to depart, this acknowledged departure from best practices was supported by a good justification or good reason. And here I would submit it would be, and what wasn't mentioned in my brother's argument is the main justification for doing so, which is that these witnesses were fearful. They had just been menaced with a gun. One of them had just been fired at by the gun. A person who had left the scene, another eyewitness, was so scared she had vomited. And there was a distinct risk, not only in this particular case, but frankly in every investigation in the city of Lawrence, that failure to abide their wishes in this regard, not to be separated, would lead to them deciding not to participate.
Can I ask about, and I know we're not supposed to do this, from on high, but he originally tries to bring them back separately, right? The officer wants to he wants to separate them at the scene as opposed to at the show-up, right?
Correct.
I guess the question I have is that potentially, that he makes the right decision at the first point, but when he brings them to the show-up and they're in the car together, doesn't that invite all kinds of problems? I understand why they don't want to be separated and one person left on the curb and the other person brought there, but don't they have to separate them once they get there? Because meaning literally they bring them there and they walk them over separately or they take them out of a different car. It just seems this gets problematic, doesn't it?
Right, and it was his desire and intention to bring them separately, and it was the witnesses who balked at this. So the question is, to what extent should he press them or urge them or badger them to separate in order to conduct this?
Did they get out of the car?
What's that?
Did they get out of the police car?
They did not.
They stayed in the police car together?
Yes, yes.
Because they didn't want to be seen?
Because they didn't want to be seen. And at the scene, there was a finding that the officer tried to assuage their fear by saying, you'll be in a tinted window car. You need not, but they refused to be separated despite that. So they were brought to the scene together.
How far away was it? Do we know that?
I believe it was within 20 feet. I'm not certain on that, Your Honor. But
Did they express any certainty?
they did. They were asked immediately after, pursuant to best practices, how certain they were. And Thomas was asked first. She said she was 100% certain in English. Escobar was asked second. Thomas translated for her. She said identically 100% certain. And before that, their identifications were simultaneous and immediate and occurred before he even asked them in the car.
Is that realistic to think they really were simultaneous? I mean, I understand the judge makes that finding, but one person screams, that's him, and the other person's not going to understand there's been an identification. But it just seems things don't happen even in, track races that one person does it at the exact same time. There's usually one person a little ahead of the other. It just seems odd that we're relying on a spontaneous fact-finding that seems very artificial.
Well, that's what the judge found, and that was Officer Guthrie's expressed testimony, that it came out at the same time, one in English, one in Spanish.
Spanish-speaking person did not understand what the English-speaking person said?
Well, there was no evidence elicited that she did, but could they permissibly argue this? Yes, they could permissibly argue, and it's conceivable that she did. But who are the fact finders who need to evaluate this and assess the weight based on that possibility? It's the jury. And they were given the instruction which in very specific terms highlighted the fact of potential co-witness feedback, not only in identification if it wasn't simultaneous, but also in their statements of certainty. So it's certainly conceivable that there was co-witness feedback in this case, but the question of whether there in fact was one for the jury.
How about on the motion to suppress? So let me ask you this. Taking into account that we don't have reliability in determining whether or not an out-of-court identification is unnecessarily suggestive or whether or not it can be saved absent clear and convincing evidence of an independent source. The simultaneous identification, can that have anything to do with the determination of whether or not the out-of-court identification procedure was unnecessarily suggestive, or does it really sort of dip into Manson versus Braithwaite?
Well, I have a few responses. The first one is that Article 12 generally looks at those system variables, those factors over which the police had actual control in the course of the things. And obviously the fact that they simultaneously identified it was not something over which the officer had particular control. So it looks more like a system variable under Article 12. But that's not the way this court has repeatedly applied Article 12. In Watson, in Martin, it has said that a witness's certitude is relevant to, in their identification, is relevant to whether the whole encounter considered in the totality was unnecessarily suggestive. That's the way this court has in the past interpreted Article 12, rightly or wrongly.
Ron?
That I would submit no, because you need to look at susceptibility to co-witness feedback. And so I would say those decisions are correctly decided, and this case would be in line with those under Article 12. But of course, Article 12 isn't the only thing the defendant claimed below. He claimed common law principles of fairness, and there's no argument that that is not a relevant consideration as to an evidentiary judgment on the reliability. As we know, Johnson is the standard, and Johnson was decided right before this case, so the judge had it in mind. That was right before the hearing, so he had it in mind. And the other is he did make a claim under the federal Constitution, so that would bring in the Braithwaite reliability analysis. So it was permissible under Article 12, under common law principles of fairness, and under the federal standard, which the court was bound to apply as well.
So what do we do with, I mean, it's not great to have two witnesses
Certainly.
together, and it's not, and although you say they were simultaneous, they were both basically put in a car and the spotlight was put on the individual, so the police were responsible for the fact that they each heard each other do it. And this usually occurs when you've got two victims, so the fear and the apprehension is pretty routine in these types of situations where there are two people. So what makes this different from others, or are we risking having the exception devour the rule that you don't generally do this?
Right. Well, this one was conducted, unlike any other one I could find that this court has reviewed or that the appeals court was reviewed, within 10 minutes of the actual events. Typically, it's a longer period of time where the fear is allowed to dissipate somewhat. Obviously, there's a benefit to accuracy to doing it closer in time. So the officers did so. So the fear was, the exception won't justify the rule, because I don't think this will, there's been no other case that we've seen, A, that was this close to the events, B, in which they refused to be separated out of fear. I think it's a fairly unique set of facts here.
Are those the facts, though, that Judge Lang found that they refused to? I mean, do we have in the, I read the motion, the decision a while ago, but is there some obligation of the police officer to sort of push back, press at least to some extent to try and separate them, cognizant that they may lose the identification completely and with that concern in mind?
Well, I think to the extent there was here, because there was evidence, or is an inference on the record that there was, and that arises from the fact that after they told him they were afraid, after he gave them, the instruction that I mentioned, he said, "We have a tinted car. He will not be able to see you." But my reading of the facts is that they continued to refuse to be separated. It was his desire and intention to do it separately. He was trained to do it separately. And as he put it candidly in cross-examination, when they refuse to be separated like this, you have to do what you have to do. I think the public safety justification here was among the most compelling that this set of facts that this court has been presented with. Here we have what is really an active shooter rampaging down the streets of Lawrence, and the need to identify this person as either being that person or not was as immediate as one can imagine.
Okay, thank you.
Thank you very
We'll
much.
take our morning break.